This is the matter of Heidi M. Weber and Michael R. Weber. This is the time and date set for hearing for entry of judgment of divorce and motion to accelerate waiting period. The parties are present in the courtroom. Appearing on behalf of party A is attorney Andrea M. Banfield. Will both parties please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Thank you. Ms. Banfield, you may proceed.
Good morning. I'm not sure if I placed my name on the record. Andrea Banfield on behalf of Heidi Weber, party A in this matter.
We covered it twice. I mentioned it as well. So go ahead, please.
Okay, thank you. And I have several statutory questions for the proofs of divorce that I would like to ask of Ms. Weber. Would the court prefer me to start with a motion? Or can I do it simultaneously
let's get
together?
Let's get the proofs in first, and then we'll deal with the motion to accelerate.
All right, wonderful. Thank you. Heidi, if you could state your name for the record.
Heidi and Michael Weber.
Did you file a petition to enter a consent judgment of divorce?
Yes.
And were the allegations in that petition, were they true at the time that you signed the petition?
Yes.
And are they still true today?
Yes.
And at the time you signed the petition, it was filed with the court. Had you resided in the state of Michigan for at least 180 days?
Yes.
And had you also resided in Huron County for at least 10 days?
Yes.
One of the allegations in your petition was that there was a breakdown in the marriage relationship to the extent that the bonds of matrimony have been destroyed and that there is no reasonable likelihood that the marriage can be preserved. Does that remain to be true today?
Correct.
And were 2 children born to your marriage?
Yes.
And are you pregnant?
No.
You signed both a settlement agreement and a judgment of divorce, is that correct?
Correct.
And in those documents, you made arrangements with regards to custody, parenting time, child support, and other financial matters with your spouse, is that correct?
Correct.
And do you believe that those arrangements are in the best interest of your children?
Absolutely.
One other thing that you've asked is that the terms of your settlement agreement be incorporated in your judgment of divorce. Is that also correct?
Yes.
Your proposed judgment that we presented to the court, did you have an opportunity to review it?
Yes.
And are you agreeable with the terms contained in the judgment of divorce?
Yes.
And did you sign it?
Yes.
And did you recognize the signature of your spouse when you submitted it to my office?
Yes.
If the court was to deny you a request for divorce, would you ever live again with your spouse as husband and wife?
No.
Do you understand by submitting a joint petition to the court that you're waiving your right to a trial in this matter? And by signing the judgment, you are stating that you are fully satisfied with the provisions of the judgment of divorce, even though you did not go to trial?
Yes.
Do you understand that there is a 6-month waiting period with children when requesting a divorce in the state of Michigan?
Yes.
And are you asking the court to waive the statutory waiting period in your action?
Yes.
And is it because you and your spouse have worked very hard to reach a full settlement and have been separated for over a year?
Correct.
And finalizing your divorce today, would it reduce family tensions and serve to provide your children with stability?
Yeah, we both want what's best for the kids.
So you're asking the court today to waive the remaining portion of the waiting period, is that correct?
Yes.
And do you understand that my office has only served in this action on a limited scope basis.
Yes,
Are you now asking the court to sign your judgment of divorce and all support orders in your case?
yes.
And do you have any questions for me?
No.
Thank you. I have no
Counsel,
further
regarding,
questions of Ms. Weber.
all right, thank you, counsel. I have some general questions of you to ask your client regarding the position of the parties regarding AMW 1 and AMW 2 regarding the custody arrangement, whether that's in the best interest of the minor children.
Ms. Weber, the custody and parenting time provisions that were placed in your judgment of divorce, do you believe it's in the best interest of your children and you're asking the court to adopt those provisions?
Yes, we both have access to the kids all day, every day.
Counsel, under MCL 552.9F, in cases of unusual hardship or such compelling necessity, it shall appeal to the conscience of the court upon petition of proper showing. It may take testimony at any time after the expiration of 60 days from the time of filing the bill of complaint. The court has heard that the parties have worked very hard, which is very admirable, but there was testimony regarding family tension and providing stability, but I'm hearing testimony from party A that they both have access to the children all day, every day. So where's the compelling necessity or unusual hardship?
Would the court like me to inquire further with my client?
Please, thank you.
Certain financial arrangements were contained in your confidential settlement agreement. Is that correct, Ms. Weber?
Yes,
And would it be a financial benefit to your family to be able to be divorced and proceed with the financial arrangements in your confidential settlement agreement?
yes,
If the court would deny you a divorce today, would it be an unusual hardship for you to wait out the remaining portion of the waiting period, resulting in you not being able to finalize your financial agreements that were laid forth in your judgment?
yes,
And because of that financial hardship, would it go against the best interests of your children?
yes.
I have no further questions with regards to financial hardship, Your Honor.
All right, thank you. Ms. Weber, what is the financial hardship?
This is the last piece of the puzzle is, we've been for a year now taking care of the kids, seeing them all the time. It's just now we need to have the financially separated to where he has his, and then I have my money, and this is like the last piece of the puzzle that needs to be done. We've all set into our new routine.
Okay, but how is that unusual hardship?
I guess I'm not sure. I
That's
mean,
what I'm asking. Or such compelling necessity.
like to be able to have my money to be able to separate the bills and live on our own. That's what, I just need him to be able to pay me and then me to be on my own.
All right, so are you saying that if the divorce is not entered today, that financially it would be, if not extremely difficult, impossible to continue with the arrangement that you've worked out? Is that what you're saying?
I mean, it would be easier just to have the financial stuff done and then start living on our own. This is the only thing that we don't have worked out.
All right. Any further proofs regarding, or any further questions regarding your client, counsel?
Yes, Ms. Weber, in your settlement agreement, there's specific provisions with regards to dividing financial investments, particularly retirement accounts.
Yes,
Isn't it correct that you need access to those retirement accounts and that to provide for your family? And if you're not divorced, and the waiving of the waiting period is not granted today, that you will not have access to those accounts until getting divorced?
correct.
And do you believe it would be in the best interest of your children to be able to access those retirement accounts to financially provide for your family?
Yes,
Would it cause an undue hardship to have to wait another 4 months to have this divorce finalized because you would not be able to access those financial investments?
yes.
Thank you, counsel. My understanding, this would be joint legal, joint physical, correct? And that's in the best interest of the children
Yes, the kids need both of us in their life.
and myself. Do you wish to have your previous name restored?
No,
You're not currently expecting, correct?
no,
Neither party shall remove the domicile of the minor children without approval of the court. Is that your understanding as well? Not where you, if you want to go on vacation, I'm talking about where the children currently reside.
Yeah.
You can't move out
Yep.
more than 100 miles. And you wish to be exempt from friend of the court services?
yeah,
And it appears that you'd be awarded spousal support. Is that correct?
correct.
And that would be for a period of spousal support shall terminate either upon, God forbid, your passing or 5 years and 4 months from the date of the judgment today. Is that correct?
Correct.
However, any spousal support for party B is forever barred.
Correct.
Okay. Are there any other assets or any other debts that have not been addressed in the proposed settlement agreement?
No,
All right, thank you. Counsel, do you wish to question party B?
Yes, briefly, Your Honor.
Go ahead, please.
Mr. Weber, did you understand that my office did not represent you in this matter?
I do, correct.
That you had to write to retain counsel and you chose to voluntarily not have counsel appear on your behalf today?
Correct.
And would your questions, or not your questions, would your answers to the questions that I asked of Ms. Weber have been any different?
No,
Thank you. I have no further questions of Mr. Weber.
I do. Mr. Weber, did you hear, or did you also review the proposed consent judgment of divorce as well as the settlement agreement?
yes,
And you understand it?
yep,
And you agreed to those terms?
yes,
Are there any other assets or any other debts that you're aware of that we've not covered on this record?
nope,
And do you feel that the custody and custodial time arrangement is in the best interest of both of the children?
I do.
All right, thank you. Any further proofs, counsel?
No, thank you, Your Honor.
All right. Well, court clearly finds, based upon review of the file and the testimony, the statutory grounds for divorce have been established. The question, though, before the court is under MCL 552.9F, whether or not the waiting period should, the 6-month wait period should be essentially waived. And as stated, there must be unusual hardship or such compelling necessity as shall appeal to the conscience of the court upon petition and proper showing that it may take testimony at any time after the expiration of 60 days from the time of filing the bill of complaint. To be honest, originally speaking, after review of the file and hearing some of the statements of party A. That finding was not made. However, after further questioning of it, it's close, but in this circumstance, the court will find unusual hardship based upon a financial concern. As a result, the judgment of absolute divorce is granted to the plaintiff. I should say party A, Heidi Weber, from party B, Michael R. Weber. The custody and parenting time arrangement is in the best interest of the minor children. Parties shall have joint legal, joint physical custody. Either party shall remove the domicile of the minor children from the state of Michigan without prior approval of the court. Parties are awarded custodial time as outlined on the record, and it would primarily, I shouldn't say outlined on the record, what's contained in the proposed judgment. Party A is awarded spousal support according to the terms of the settlement agreement and the proposed judgment. Any spousal support on behalf of party B is forever barred and is not ordered. The judgment shall include the property division that was outlined in the settlement agreement, as well as any and all provisions as well concerning pensions and life insurance. Counsel, was the standard medical insurance provision be provided in this matter?
Yes, we did have a uniform support order for no friend of the court services that included those provisions.
Okay. All right. I saw the order or the proposed order. I just didn't hear the testimony regarding that. The court will accept that.
Thank you.
As a result, the court has executed the consent judgment of divorce in this matter, as well as the order exempting the case from friend of court services. The court has also entered the support orders that has been submitted to the court. I wish to thank both parties for being able to work this out, especially with two minor children. And at the end of the day, above all, though you're going your separate ways, you have two common interests in mind, and that's most important. So you keep that in mind. These children will succeed just as both of you are succeeding. So I wish you both the very best. That'll be all. Thank you. Thank you, counsel.
Thank you, Your Honor.
Okay.